Just past 7 o'clock. First item on the agenda, approval of the minutes, please, December 4th. Motion?
The motion to approve.
I have a motion, I have a second. Any further discussion? All in favor?
Aye.
I thought Amy should be in here. Mr. President.
Would you like to make a proposed revision?
A revision, because Amy was present at this meeting and they didn't include her in the present. Even though she's,
Can we get that added to the minutes, please? Excellent, thank you. So once again, we had a motion, we had a second. Any further discussion? All in favor?
Aye.
Anyone opposed? Very good. Nothing under old business. First item under new business. An administrative subdivision, Fenner Hill Golf LLC, Planned Unit Development District, AP 15, lots 8 and 9, 1 Wheeler Lane and 33 Wheeler Lane, the residences at Fenner Hill Condominium Association and Fenner Hill Country Club LLC applicants. Applicant or the representative present? Come forward, please.
Good afternoon, Mr. Chairman. My name is Jeff Caffrey. I'm an attorney with the law firm of Resnick and Caffrey, 300 Centerville Road in Warwick, Rhode Island. I'm here on behalf of the applicant, Fenner Hill Golf LLC. As you had indicated, this is an administrative subdivision for property between Fenner Hill Golf Club and the residences at Fenner Hill. And quite simply, what we're looking to do is to restore 15 acres to the area of the golf course. That was the area that was originally designated for phase 2 at the residences at Fenner Hill, scheduled to have developed roughly about 40 units on that phase. Basically what we'd like to do now is incorporate that into the golf course so that the golf course can have some unobstructed use of the area. Some of this involves the parking area. Some of the practice area has been gradually encroaching upon the land of the condominium. So we'd just like to restore that back to the golf course. Does the board have any questions?
Very good, thank you. Jim, any comments from your perspective?
Well, I referred, something of this nature I would normally do myself in the office, but because this was part of a planned unit development for both lots 8 and 9, and a planned unit development is something that the planning board develops in conjunction with the town council. Town council actually changes the zone on this land to planned unit development. And so because of that nature and the fact that 26 units would no longer be built, I just wanted the planning board to take a look at it and see if you are on board with something like that.
Very good. Okay, appreciate that. From the legal side, any issues with this, if you will, joint approval from the planning board and town council? Are we entitled to act on this without the benefit of town council input?
Yes, you can move forward on this evening.
Planning board questions or comments of the applicant?
I'm unfamiliar with the project, so was phase 2 the end of the residential development?
Well, there's another 16 units that are subject to be developed, and then this would have been developed after those 16 units.
Okay.
So this would have been the very tail end of the project.
Okay, so that's part of phase 1?
The remaining 16 units are part of phase 1, and this would be part of phase 2.
Okay.
What is the status of the 16 units?
There's four. There's four actually that are being built now that would get it up to 28. Would get it up to 28. Then there's another 16 that the development rights have actually expired on, which the association may or may not decide to revive those development rights for purposes of future construction.
Okay, thank you.
Sure.
Planning board, anything else?
You mentioned a little bit about what the 15 acres is going to go back to the golf course to support. It says to improve operation of the golf course. Can you just talk a little bit more about exactly how the land will be used?
Sure, at this point in time, there's really no intention to do any development with the area. Matter of fact, we had to enter into an agreement with the unit owners association that the land would not be developed by us. The only caveat being that if we felt it necessary to expand upon any of the golf operations, that we would have the ability to do so. So Ron LeVay, who was here, had mentioned that perhaps they might want to put some practice area over there. And part of the area is already being used as parking for the golf course. So I think that the potential could exist perhaps for having to expand the parking area depending upon the needs of the golf course. But at this stage of the game, there's really nothing concrete that's being proposed.
My question may be more for you than him, but if there were improvements on these 15 acres, would that come before you, or once we give approval, if he can do anything on, is it green lighting him for anything to do on that property?
He would have to apply for building permits,
Right.
and I believe he'd be able to do anything in conjunction with the golf course operations, any accessory buildings or whatnot that could be built.
Okay.
Just so I'm clear, this doesn't change any of the permitted uses in the property at all, it's just a matter of changing some boundary lines, is that correct?
Yep.
That's all?
I realize it's an administrative subdivision, doesn't normally involve public participation, but is there anyone in the audience that wishes to comment on this application this evening? I see no hands. Planning board, time for a decision. Anyone care to make a motion?
No,
Well,
that's the answer.
Googling themselves on.
Okay,
I'll make a motion to approve the administrative subdivision, Benner Hill Golf LLC Planned Unit Development District.
keep in mind that the approval needs to render the findings outlined on page 2 of Jim's.
Okay.
You wanna just recite those for the record?
Sure, so make a motion to approve the administrative subdivision at Benner Hill Golf LLC Planned Unit Development District. Contingent on the fact that each subdivision is consistent with the requirements of the Hopkinton Comprehensive Community Plan and shall satisfactorily address the issues where there may be inconsistencies, that each lot in the subdivision shall conform to the standards and provisions of the Hopkinton zoning ordinance, that there will be no significant negative environmental impacts for the proposed development as shown on the final plan with all required conditions of approval, that the subdivision as proposed will not result in the creation of individual lots with such physical constraints to development that building on those lots according to pertinent regulations and building standards would be impracticable, that all proposed land developments and all subdivision lots shall have adequate and permanent legal access to a public street, that each subdivision shall provide for safe circulation of pedestrian and vehicular traffic, for surface water runoff control, for suitable building sites, and for preservation of natural, historical, or cultural features that contribute to the attractiveness of the community. And finally, that the design and location of streets, building lots, utilities, drainage improvements, and other improvements in each subdivision shall minimize flooding and soil erosion.
Outstanding. I have a motion.
Second?
I have a second. Any further discussion? All in favor?
Aye.
Anyone opposed? Done.
Mr. Chairman, just one point of clarification. The initial part that you read into the record was that it was contingent upon those things occurring, but I think it's been a determination that in fact we've met all of those requirements. Would that be a safe assumption?
I'm sorry, the question again was?
The initial statement that she made when she was reading into the record, that I think she was in favor of contingent upon the enumerated items, but I think the finding would be that we've met the requirements of those enumerated items,
Yes.
and therefore it's not contingent upon that.
I believe that was the intention, yes.
Okay, yes, thank you.
Very good. Thank you very much. Thank you. Under new business, a pre-application, major land development project, Fairview Estates, AP 18 lot 7K 66 Fairview Avenue, Shoreline Properties Inc. applicant. And if I may, there needs to be turned around to face the audience, please. Thank you. We have several pre-applications before us this evening. This is the first of two. Before we get started on this particular application, I'd like to read to you the definition of pre-application meeting so that there's no confusion as we delve into both this application and, perhaps more importantly, the second. So bear with me, please, while I read a paragraph. The pre-application meeting is the initial stage of land development and subdivision review in which proposals are discussed informally and receive comments and direction from municipal officials. Pre-application meetings shall aim to encourage information sharing and discussion of project concepts among the participants. Pre-application meetings should include a review of the physical character of the land and any environmental or physical constraints to development. Meetings should include a discussion initiated by the planning board regarding what form of land development may be appropriate to meet the goals and policies of the comprehensive plan with regards to preserving the character of the land, the natural environment, and the ability of the town to provide essential services. Pre-application discussions are intended for the guidance of the applicant. It shall not be considered approval of the project or any of its elements. No formal action need be taken by the planning board at the pre-application meeting. Everybody clear on the words? Any questions? Very good, thank you. You have the floor.
Good evening. My name is Patrick Freeman. I'm a registered professional engineer. I work for American Engineering. I'm representing Joe Catelli, the applicant, under Shoreline Properties. We're proposing a 4-lot major subdivision at 66 Fairview Avenue. The lot is located on the easterly side of Fairview Avenue. It's known as Assessors Plat 18, Lot 7K.
My apologies. Perhaps if you could just take that board and place it closer to where Dan is standing. Very good, thank you. So that the planning board can see some of it, but primarily that the audience can view it. That's perfect right there. My apologies for imprecise directions.
Okay. The existing conditions plan shows the existing duplex on the lot that's serviced by 2 approved house, as well as the existing well. There's existing wetlands in the easterly portion of the lot. As you can see, there's a pond as well as a wetland area that's just off-site to the east and a small wetland area to the south. The conventional yield plan shows how it would look under normal circumstances for a subdivision. It would be 4 lots, 2 duplexes, and 2 single-family residential units. Those would all be serviced by private wells, as well as house designs. The road would be standard 50-foot right-of-way with a cul-de-sac. We're proposing a cluster development which uses smaller lots, has more open space, and will overall have less impact on site. It would also have 2 duplex units, 1 existing, 1 proposed, 2 single-family residentials. The single-family residentials require a lot area of 40,000 square feet. The duplexes are 60,000 square feet. We've minimized the lot areas to try to keep the disturbance towards the front of the lot and away from the wetland areas in the back. We've provided double the open space that's required. With that in mind, we also are requesting to reduce the open space buffer on the southerly portion of the lot and the northerly portion of the lot so we can keep all those lots towards the front.
good, thank you. Planning board, thoughts, questions?
Okay. He knows what's coming.
He's got his glasses on.
I spent quite a bit of time with the zoning official, just to clarify in my mind what was actually being requested and how it actually fit into the zones. The zones themselves, the zoning regulations themselves, as filed, are quite contradictory. On the face of it, it says that this doesn't pass because in RFR 80, they have to be 80,000 square feet. If it's a duplex, you have to times that, times how many people, well, a multiplex unit, if it's a three-family home, that has to be multiplied 3 times 80,000. But then it goes on to say that during a cluster application, they can change that. Now, the information mostly comes from the zoning, I didn't write down what the actual name of the book is. It's the zoning regulations that our official has in our office. And in chapter 123, in the general ordinance of the town of Hopkinton, there it is. On the cluster development, there is no increase in the number of lots over which would be permitted under conventional development. There again, it goes on to say other things. Letters that were filed in 2011 say that it's not legal. So there's a big gray area there that was very gray in my mind. And when I asked the zoning official, it's gray in her mind as well. So I'd like to ask the solicitor or maybe Jim, the planner, to kind of clarify that. You know, before we get muddied down and spend a lot of time and a lot of money with attorney fees and stuff.
Did you say, Ron, that you saw a letter from 2011 saying that this was illegal? Well, who was that letter from? Because I haven't seen that.
It's from Brad Ward, and it went into a file somewhere.
Okay. Well,
I may have a copy of that here.
Well, just to clarify, the provisions for cluster subdivisions are a part of the zoning ordinance. It's a special type of development that has smaller lot sizes. It's a trade-off between a shorter road, which is better for the town, and less expensive for the developer to do. They get smaller lot sizes. Open space is a part of it. In other words, a cluster subdivision has different standards than a conventional subdivision from our zoning ordinance, if it was done, you know, RFR 80 wise. So the lots do not have to be, I mean, they don't have to be 80,000 square feet in a cluster. There's all special provisions for it. And even though our ordinance now, our zoning ordinance might not word for word have the cluster in there, if you read the zoning ordinance carefully, you'll see that the cluster is a part of it. Residential compound is a part of the zoning ordinance. PUD is a part of the zoning ordinance. All of these things that deal with land development projects are a part of the zoning ordinance. And so.
On that note, in the cluster development, am I fuzzy or did I read the ordinance? Homeowners association required with this type of a development?
Yes.
And this development would be responsible for maintaining its roads and et cetera?
Well, let me qualify that for 1 second. Not necessarily. If the cluster is to be owned by one entity, you probably don't need an HOA for that. But if it's going to be, and the open space in that case could be owned by that entity. It all depends how the ownership of the property is structured. But quite often, you would have a developer sell off the individual lots. An HOA would be formed. They would be responsible for maintenance of the open space and use of the open space. So it all depends what they have in mind.
On that
Do you
note,
know?
do you know what you have in mind?
Joe, we were thinking a homeowners association for the individual, for the parcels, and I believe we were gonna maintain the ponds, as
Yes.
well as the road. Yeah,
Yep.
we're proposing a private road, so that would be part of the homeowners association.
Thank you.
At some point, does that private road revert to or change itself into a town road where the town would be responsible for maintenance, or, no, it's gonna remain private road?
Remain private road.
I found what I was looking for, it's page 1741, it's section 6, number 6 at the bottom of the page, that's what I was saying about the contradictory part.
Okay.
Because that states, you know, you still have to be at 80,000 square feet, but there are other things, section 123 contradicts that. It's, in my mind, it's a gray, kind of a gray area, but listening to Jim, I mean, he's way more up on this than I am, so I have, you know, defer to him.
Yeah.
Could have been worded better on, I guess, to avoid ambiguity, but.
What page was that again?
1741, section 6, number 6, bottom of the page.
In my absence, did we deal with the reduction of the 100-foot buffer?
No.
No.
Okay. So that was my primary concern, specifically the reduction along the northerly boundary line between the proposed roadway and lot 77.
Correct. So we,
I'm uncomfortable with that.
okay.
So unless you're going to propose, and I don't even know how you can do it in, I believe it's a 9-foot width. I was gonna say unless you're prepared to propose a dramatic replanting or revegetation screening area, 9 feet is inadequate. If I were the abutting property owner, I'd be hostile. So in trying to look out for the best interests of that property owner, you've gotta do better than 9 feet. I appreciate that you have other constraints, but a reduction from 100 feet to 9 feet, I'm uncomfortable with it, my personal perspective. That is not having viewed the site. I don't know if that's a barren strip of property or whether it's densely vegetated, but almost regardless, 9 feet simply doesn't do it for me.
Okay. That's actually, we followed the existing contour of the gravel driveway that was initially installed for the yield plan.
Yep.
So that's where the existing road goes. We proposed there to follow that contour. It's already been graded. It's already been cleared. The dwelling on the abutting lot is very close to Fairway Avenue. There's a little bit more buffer there, and you definitely could plant that. We don't have a landscape architect at the moment, but we can get one and come up with a buffer plan that suits you.
I follow your logical thinking, but simply because somebody cut a road in there all those years ago, it doesn't sway me.
Do you have a preference in size of buffers or something you'd like to see there that would make you feel more comfortable?
I do not. So you're gonna go back to my reading of the pre-application definition, right? This is my opportunity to share with you my thoughts. So the whole concept here of a 100-foot buffer was clearly to screen the proposed development from the abutting property owners. I'm going to put this onus back on you and say, you need to satisfy that objective. So if you can't give 100 feet, which is understandable, you need to come up with an alternative that satisfies that objective. So whether it's by screening or an increased buffer area, I leave that up to you. I'm not gonna give you the number. I'm not designing the project for you. You need to come back to us with something that satisfies that objective, in my mind. Alveola's opinion.
Thank you.
Anything else, planning board members?
I have another, I won't call it an issue, but that heavy black line that's in the back there, now, I've lived in this neighborhood for 68 years. When I started school in 1955, late 1955, 1956, that was always called Goat Rocks. And it was always the local accepted rumor, or whatever you wanna call it, that that was Indian religious ground, that they had ceremonies there and whatever. Whether or not it's a local, whatever you call it, just a rumor, a legend, or if it's actually Native American spiritual property is unclear to me. I took it upon myself late Friday afternoon to call Mr. Doug Harris. He's the local American, Native American specialist, and he said he was gonna look into it and get back, so I don't see him here. So he may be still getting the information together, I don't know, because he wasn't clear himself. He knows that it has been used by the Native Americans for as long as he can remember, but the actual status of it, you know, if I came to your house and sat on your front lawn every day, it doesn't make it my property to sit there, you know what I mean? So, that's, you know, unclear to me, that specific little area there.
Do you have Doug's contact information? Maybe I can get in touch with him.
I do. I can give it to you later, or
That's fine. Yeah, thank you.
that way we're not, you know, kind of broadcasting it out. And get it, you know. Well, I'll give it to you when you broadcast it.
That's a good point. Anything else, planning board members?
I'll just say, I had the same concerns about the reduced buffer in the northern part. The southern part, it looks like you did, you know, do your best there. So I would also like to see, an alternate plan for that northern buffer especially. But overall, I would say, I'm really happy with the amount of open space preserved in this alternative plan. I'm really happy that you went with the alternative versus the conventional layout. I think in this neighborhood especially, it's worth making that sacrifice for the smaller lot sizes to keep the open space in the eastern part of the lot. So really happy to see that. Thank you.
I concur.
Yes, same concerns of the buffer, and interested to hear what the public comment is too, for if there's any residents in the area. Say, before making up my mind.
Good. You know, I just had one additional thought, based on Emily's comment that I'd share with you. So, along the southerly line, I'm sorry, the width of your proposed open space was, again?
30 feet.
30 feet. And yet, we also have an additional, what's the building setback line in that, against that rear line?
The rear line's 40.
So what if we were to suggest to you that you were to include a no clear easement within the rear setback line, I'm referring now to along the southerly boundary line, which would actually increase your, let me call it buffer in quotes, to something in the order of 70 feet. How would your client feel about that? Maybe you can chat about that and come back to us with something along those lines.
Okay.
That might give us a additional warm and fuzzy feeling, at least along that southerly line. Okay, good. So planning board, everything else, we good? Jim, anything else to add on your end?
No?
I'd echo the sentiment. I've heard a lot of public comment about the size of buffers over the past year or two, and I think that's important to recognize. And isn't this easterly boundary now abutted by a commercial zone?
I can't.
I don't know if that's the
Can't tell
exact
that.
commercial zone or not. I don't know if that makes a difference or not in terms of where the open space rests, but I believe that was recently rezoned.
No, I think that, John, I think that's to the
Northeast?
northeast, correct.
Okay.
And it might even be one additional lot removed. I see where you're coming from. I simply can't tell.
Yeah, I'm just illustrating it that on the aerial shots, it appears to be vegetated, but that may or may not be. I don't know what the status of that lot is currently.
Yeah, directly to the east is still part of the Grand Sierra Estates subdivision. But to the north or northeast of this site, I can't tell about that particular parcel.
Okay.
Point well taken though.
That's all I got.
Okay, thank you. Again, it's pre-application, the public is not necessarily part of the process, but is there anyone else in the audience that wishes to be heard on this application this evening? Yes, sir. Come forward.
Harvey Good for Conservation Commission. Just to give a little bit more feedback to what Ron said, I had actually, because our comprehensive plan calls for the town to work with the Narragansett Indian Tribal Historic Preservation Office when we suspect that there's something on a property, to get them involved to look at it. I had contacted Doug Harris about another project coming up later tonight, and he happened to mention this project to me, which I wasn't aware about it, but he mentioned the Goat Rock, and he apologized. He would not be able to be here tonight. He had been ill, and he has not been cleared, I guess, by the doctor or whatever. He's having disability right now, so he wasn't able to come tonight, but he did want to convey that he would like to speak with the folks. And I didn't see where's the open space line towards the east?
So this whole area is
Okay.
actually
So,
open space.
so I would just say, if there is something there, this probably is one of the better ways to let the project go forward and still preserve something of cultural significance. Just my comment.
Very good. Thank you, Harvey. Anyone else in the audience this evening wishing to be heard on this application? I see no hands. Anything else that the planning board would like to pass along to this applicant at this time? Okay, I think you've heard our comments. Yes?
Yes.
Any questions from yourself?
Thank you.
Very good. Thank you.
Very much.
A pre-application, major land development, Stone Ridge at Hopkinton, EP 11, lot 47A, Palmer Circle, RI 95 LLC applicant. Is the applicant or the applicant's representative present?
Yes.
Yes, sir.
Good evening, Mr. Chairman, members of the planning board. My name is Walter Manning. I was born and raised in southern Rhode Island, and I'm an applicant and one of the members of RI 95 LLC. RI 95 LLC owns 253 acres off of Palmer Circle, known as 47A. We would like to develop, and as of now, we have named this project Stone Ridge at Hopkinton. Property is zoned special commercial, and as such, we propose to stay within the allowable uses as a matter of right, which include but are not limited to solar and commercial development. As part of the pre-application, we've been speaking with the town planner, and in the spirit of information sharing and guidance under the pre-application rules, we are here to seek any feedback that you folks may have towards this project. I'd like to introduce a couple of the experts that I have on my team. Sergio Sharenzia is a local licensed site engineer who's here to discuss the proposed site uses. Sergio. And Kevin Walkett, who's an expert on solar panels and installation, who's here to address any question concerning the solar portion of our project. Together, we hope to answer any questions you may have, any concerns either the board or the citizens here may have today. Thank you.
Very good. Thank you.
Sergio.
Good evening.
Sergio, I like the new look.
Yeah. I look the part, right? A little rustic. Like I've been out in the woods. Although you play the part a little much better. Mr. Chair, members of the board, appreciate you the opportunity to present to you this evening. For the record, Sergio Sharenzia. I'm the president and principal of Sharenzia and Associates, a land surveying and engineering company located with headquarters in Pawcatuck, Connecticut. We, all the plans that are before you this evening, have been prepared under, my supervision and responsible charge, and I am a licensed engineer in the state of, Rhode Island. On behalf of Rhode Island 95 LLC, we, prepared this, this application and the site plans that are before you tonight. Within that application, I set up 2 easels. I hope that everyone can see, and I'll try to do my best to articulate and identify where I'm speaking on these, because it is a fairly large site. As was mentioned, the site is a 252 plus or minus acre parcel located on Palmer Circle, Assessor's Map 11, Lot 47A. The property was previously permitted as Brayburn Country Club in 1993. Just to give you a little history, it consisted of an 18-hole golf course with a clubhouse. This natural site conditions right now is majority of it is in an undeveloped wooded lot. You can see it identified in the center of this map, noted by the project location, with the red line and sort of an orange line surrounding it. This is the lot here. If everyone can see that. Most of it, as I mentioned, is an undeveloped wooded lot with an overgrown gravel area around a small pond on the east side of the lot. And that's up in the corner closest to Palmer Circle. Pond appears to have been constructed sometime in the past as an irrigation reservoir as part of the previously permitted project, which never came to fruition. Grades on the property generally slope to a west, north, and east, away from a high point near the center of the lot. Slopes on the site range from 2 to 20%. The property is abutted by undeveloped lots to the north, west, and south, residential lots to the east and southeast, and farmland to the northeast. Palmer Circle provides the access to the site towards the east. And as you can tell, that Route 95 runs pretty much along its north. The soils on the site vary from many different types of soils. And getting into any detail on those types of soils if need be, but since we're at pre-app, we will be identifying as this moves forward the best soils or best areas for things such as on-site wastewater treatment and stormwater remediation. The majority of the property is located in Zone X, as far as the FEMA flood insurance maps goes, which is defined as an area to be outside the 0.2% annual chance floodplain. The Kanashi Brook is present along the northeast property line, and the area in the vicinity of the brook is within a Zone AE, which has a base flood elevation of 75. Zone AE is defined as a special flood hazard area subject to flooding by the 1% annual chance storm, with the base flood elevation determined. So a majority of this site and the portion of it that will be developed is likely be outside of any flood hazard areas. A portion of the southeast side of the property is located within a groundwater and wellhead primary protection zone, as delineated by the town of Hopkinton. An area eastern of the portion property also contains both a community and non-community wellhead protection area as defined by Rhode Island Department of Management of Environmental Management, excuse me. There have been maps that have provided that show that. I'm going to just change this over and Kevin, do you mind grabbing the other side? I'm not sure what number, I think it might be the last one. see I've colored up a few of the lines here, and you can see on that one. The green and the purple lines represent the state, community, and non-community wellhead protection areas. And you can see that they just clip the easterly portion and the southeasterly portion of the lot. And then there's also the orange line, which is the, excuse me, get these ones mixed up. The groundwater primary protection zone, and then the blue line represents the wellhead protection zone. I will make note that we used an outdated map in our original application. It was pointed out to us by the town planner that we had used the outdated map. We updated it to the new town of Hopkinton map. So those wellhead areas aren't shown in your, they might not be on the plans in the package, but I fixed them and brought them here tonight. And you can see that the outermost lines are the orange and the green, and those do cover the easterly portion of this site. With respect to stormwater, this project will discharge to the Penobscot Brook and its tributaries, and to the east, to the east, and the Tomahawk Brook and tributaries to the west. I'll just put this map back up. The State of Rhode Island 2016 Impaired Waters Report identifies Penobscot Brook as having impairments for cadmium, copper, lead, and enterococcus, and a TMDL for enterococcus. The report identifies Tomahawk Brook as having an impairment for TMDLs and enterococcus. So all that really means is that we are going to have to be diligent about stormwater management on the site and make sure that we have proper treatment before discharge off of our site, which is fully intended by my applicant, and it's going to be required by the Department of Environmental Management, Water Resources section. As far as the historical nature of this site, we have identified a cemetery on the property. We fully intend to, the cemetery is Warden Lot, and its numbers is HP 043. We fully intend to work around that cemetery. There might be a little bit of development shown over it on this one, but you can rest assured that we're going to be adjusting that in future applications to make sure that we address that accordingly. There's also a series of, as it is in a wooded lot, there's, as in most New England areas, there's stone walls and lots of trails that exist on the property. The property is not located with any natural heritage area, scenic road corridor, or state designated scenic area. There are no biking or bridle trails within or adjacent to the property. There are no playfields, playgrounds, or other recreational resources, areas adjacent to the property. With that, I wanted to go into the proposed site conditions. The applicant is proposing 5 commercial buildings and a solar facility. Each of the commercial areas shall include their own parking, utilities, wells, on-site wastewater treatment, and stormwater management areas. We've generally identified where those areas may be allocated, although that's going to have to be refined as we get more information on wetlands and as we work out what actually those buildings will be. The solar facility shall be developed with access drives and stormwater management areas. It does not require a lot of extensive other utilities besides the interconnection and electrical that goes to it. And this development shall comply with all town Hopkinton land development and subdivision regulations. It meets all the dimensional requirements as proposed currently for the commercial special zone. This is an accepted and development for that zone. We have a zoning certificate that has identified that we have the ability to construct any one of the following: self-storage, general warehousing, motels, assisted housing and nursing homes, medical, or other commercial office use. These uses are either by right for the zone or will require a special use permit. So albeit that the solar does not require any special permit, some of these uses may. The proposed solar facility shall meet the requirements of the town's non-residential photovoltaic solar energy systems, shortened by PSES ordinance. It'll occupy approximately 59% of the 215 plus or minus acre proposed property, which is under the 75% coverage for the zone. No open space is proposed as part of this subdivision. As I mentioned, we have to do stormwater management and on-site wastewater treatment to all town and state standards. Rhode Island freshwater wetlands and Rhode Island pollution discharge elimination system, RIPTs, permits are required for the proposed project due to the presence of wetland and because the project will be greater than an acre of disturbance. Development is commercial in nature and does not include any residences. Therefore, there will be no increase in population of school-age children as part of this proposed project. I think that covers most of the technical aspects of the project. I'm happy to answer any questions unless there's, Kevin had any presentation, or we're just gonna field
No,
questions?
Kevin's here for any solar questions, and Sergio for any site plan questions.
Our solar consultant is here. If there's anything specific itself to the solar development, I will do my best to answer any other questions.
Very good, thank you so much. Planning board, questions, thoughts?
A lot of them.
Yep,
It just basically, doesn't this exceed the 3% ruling we had? It's residential.
doesn't,
My question is, there's, you know, an array of uses for these buildings you wanna put up. Do you have it narrowed down? Because it's all over the place. You know, you're gonna put a 30,000 square foot floor space buildings up for what? That's, you know, general, you know,
We haven't defined specifically, because we're at the point in this pre-application that, you know, we're looking for guidance as well from people in the town. We've heard anything from, they want a supermarket in that area, they want a CVS or a gas station. We just propose medical, maybe facilities, anything that's allowable right now. And then of course it comes down to what sort of resources we can put in that are viable. You know, we're not gonna put up a lot of money if we can't get any return on it. So it's kind of a balancing act right now, but we just wanted to get this application in front of you so that we can get some feedback this early in the game. You know, there's a long process to this. So your answer is not, no, we don't have specific.
you don't have anything.
We were thinking medical, but
Yeah, I thought the self-storage, the medical, maybe senior, blah, blah, blah. Gas stations might blow me away, you know, supermarket, that's interesting.
yeah, we weren't thinking that would be something that would make it there
Yeah,
anyway.
yeah.
So we're on the medical side right now.
Yeah, yeah, it's just so, it's such a big scope that I was hoping that you'd be drilled down just a tiny bit more on it, but I understand and appreciate where you're at.
all right, I'd like to suggest that we take a step back. There's been a representation that this is an allowed use. I'm not prepared to accept that. I think we need to go further back than that. I may be one of the last people standing when this actually took place and when the approval was granted. And clearly, at that time, the vocabulary that we're using today was not even contemplated. So to automatically jump to the fact that solar is allowed here is not really acceptable to me. I'm not prepared to accept that just yet. As I look through some of the earlier documentation, I don't see that the bill of goods that was sold to the town council for the rezone reflected anything resembling your application. So, again, you heard me outline the concept of the pre-application discussion. My thoughts are, we need to go back to what the town council and the planning board approved back when this was rezoned. Does not include solar. So we need to start the conversation at that point, not the fact that you're allowed to do this by right. That's my 2 cents.
I spoke with the zoning official, again, with this and the other project at length, and she looked up a lot of things, and according to her interpretation, this is legal under commercial. That's pretty much the Reader's Digest version. You know, she quoted this page, that page, this and that. Under commercial, it doesn't specifically say solar, but under the regulations of the zoning ordinance, it's legal in a commercial zone, and it meets the other stipulations. And that's, like I said, according to the zoning official, as of Friday afternoon.
Got it. Planning board, anything else? This is your opportunity to guide the applicant.
I have a question regarding the original zoning amendment related to the reclassification as commercial special. It's my understanding that commercial special means that the town council put certain limitations or restrictions or conditions on the zone change, and that's what the special denotes. And those conditions, limitations, or restrictions are carried through with the property as they remain that commercial special zone. In that document, which is available, Al's got it right here, but it actually, thank you, it actually describes that at least 40% of the total area of the planned development, exclusive of wetlands, ponds, marshes, protected natural areas, but inclusive of golf courses and similar open outdoor recreation areas, shall be set aside as open space. A minute ago you said no open space is proposed in this plan, so I'm just curious if you can rectify those 2 things for me.
I don't think I can at this time. So you're saying that because it's a commercial special, can we find it under commercial special? No, we have not contemplated any open space. No, please. Now, does that stipulation say for golf courses? Could you read it again, sir?
Yeah, sure. It says at least 40% of the total area of the planned development, exclusive of wetlands, ponds, marshes, protected natural areas, but inclusive of golf courses and similar outdoor recreation areas, shall be set aside as open space.
Yeah, we need a determination on that. I can't answer that right now.
Okay. So that's available. I asked Jim, the planner, to email it to me beforehand, knowing that there was a zoning amendment that took place to even designate this property as commercial special. So that's,
And that's a planned unit development?
yes.
What is that?
Listen, you realize that this was pitched as a hotel, a conference center, a golf course, swimming areas, country club, water distribution, and waste treatment, right?
Mm-hmm.
That's the way this was pitched to the town council and the planning board way back when.
Okay.
That's what the rezone was predicated upon.
Understood.
Now you're coming in with a completely
something
different proposal
Okay.
and hinging it upon this approval.
Okay.
I see those 2 things as incongruous. So that's why you're starting up here with the discussion.
Mm-hmm.
I don't mean to be combative, of course. You're starting up here.
I'm just trying to understand.
I'm
That's all.
starting
not
down
making that
here,
Yeah.
where the approval was actually issued.
Mm-hmm.
So, in order to gain my support, and Emily might be on the same page, you need to get back to that
Back to this.
central issue of how this proposal satisfies this language. Because this is what the town council approved back when.
Okay.
Okay? So if you're not familiar with how it got from here, you need to go back and take a look.
There was some discussions on it reverting back to a commercial state. But we went through this thoroughly with planning staff, but it sounds like we should revisit it and get a determination. Because we did receive a zoning certificate to say that the solar was approvable, but if we need to be more in line with that, then we'll have to look into it.
So, I don't mean to take exception with our zoning official.
Mhm.
The pre-application format is an opportunity for the planning board to tell you how we feel about your project. I'm
Well,
telling
thank
you how I feel about your project.
Very much appreciated.
And the other members will do the same.
Yeah.
This is not to necessarily contradict, well, maybe it does contradict, but, you know, the zoning official can issue whatever opinion she feels like.
Mhm.
That doesn't mean it gains my support.
Understood.
Okay.
The document that I have, this is gonna make a lot of friends with our chairman, I'm sure. It's dated February 1st, 2011, and it reverts back to the January 2nd, 1990 ruling of the town council. And it says, as your request, I researched the special zoning conditions imposed January 2nd, 1990 by the town council for the above referenced lot. I have concluded that plat 11, lot 7D may be used in the following manner, as permitted in the manner with which restrictions identified in July 1990 amendment, a copy of which is attached, as permitted by right, the zoning code, chapter 134, adopted 19 December 1994, is a commercial zone. And it goes on, but when I spoke with our current official, she said under the commercial zone restrictions, what you have proposed is legal. So this, you know, here again, I don't wanna tell you your business, this is the research that I found as of Friday.
What was the lot number on that one though, Ron?
47D, but it goes on to say that includes all of lot 47. Lot 11, plat 47D is specifically noted. And it goes on further in the letter to say that
Yeah, so-
all of 47 is included.
So to clarify my concern, if the rezone was issued based on a current set of commercial uses back in whatever the date was, the presumption appears to be that whatever is allowed in commercial today should therefore be allowed. I'm not prepared to accept that, because solar was not even, a variety of commercial uses, was not even in the vocabulary when the commercial rezone was implemented. So this quantum leap from whatever's good today must have been somehow considered back in 1990 or whatever it was.
1990.
I don't get that. I don't see how that can be true.
And this letter, as I stated, is February 1st, 2011.
Yeah,
I understand your point.
They can make
That's-
whatever presumption they
This
want.
has to be
It simply
clarified.
doesn't gain my support, is my only point.
I mean, if you wanna think about it hypothetically, which may or may not help in this situation, but I'll throw this out there. Let's say they don't put a development on this land for another 20 years and they hold on to it, it's still commercial special. And then they come to us with a proposal to put a Tesla rocket launch pad there. Is that okay?
That would be a question for 20 years from now.
That states it much better than I did. Anyway, planning board members, other thoughts for the applicant? This is your opportunity.
Fast forward to today, the solar and the commercial buildings, they don't make sense together. In other words, if you got approval just for the commercial buildings and not the solar, would you still build the commercial buildings? One.
My understanding of the project is that they would have to go together,
Yeah, okay.
and the solar is the primary.
And have
which
you
will
had any
facilitate-
discussion with National Grid about connectivity?
We're in that process. Kevin, did you wanna?
Yes, we've already engaged National Grid, we put the application on file, and have had preliminary meetings with them.
What is the estimated lead time for that?
No, we haven't quite gotten to that point, thank you. Anything else?
Yeah, I could just keep going, you know, there's some outstanding issues about decommissioning and reforestation and I would just caution you to be aware of what those numbers are, cause whatever may be in place now probably may not be the same by the time you come to this board with the formal presentation, so those costs are, you know, I would just caution you to take those into consideration as you're.
Could I get a point of clarification on those two things?
Specifically,
Yeah, the reforestation, is that something that's required by your ordinance?
I do not believe so. No.
Okay. But decommissioning
Decommissioning
is?
is.
Okay, I just wanted clarification on that, because that's what I thought. Thank you.
Yep.
On the forestation part of that, what this community appreciates, community, I'm not speaking for myself, is preservation of forest land. And we've got some spaces here where they're just your standard 25-foot setback. At the end of the day, if there was gonna be an argument, we've seen in the past that these solar developments don't really look good with the 25-foot setback, regardless of what's behind it, whether it's a wooded field or someday somebody will put a house there. So I would encourage you to maximize the technology in the solar park if we're gonna go in that direction, but be sensitive to what you're taking away. The cost for that has to be included, you know, it's a negative impact. It might not be because the site is nothing now, trees and sand. At the end of the day, when you put your building up or you put your solar panels up, there's still gonna be that kind of a negative impact. And there are other people that can go into that, but be sensitive to the community, because that's a lot of what they're gonna be looking for. You know, it's a huge solar farm.
It's a big area.
Does it need to be that big? Is there better technology by the time you guys get around to doing that, that's gonna allow you to generate that kind of electric with better technology and reduce the footprint?
I can tell you that we went to the maximum on this.
You sure did.
It's much better to come in with what you can do per the regulations, in my experience, and then work back to your restrictions from there. And we will take consideration into buffers and the you know, having more space not taken up by it.
Yeah.
We will take consideration.
And I think a really big challenge for you guys would be the water runoff and how you're going to mitigate that.
I've done, just for the record, I've done probably over 5 solar projects to date. It's relatively new, but you know, we've permitted multiple projects through Rhode Island DEM, and we typically have a pre-application meeting, make sure that we understand what the requirements are going to be for a site, and any specific challenges that we will have on it before we start going to design. So, and I think we might do that before master plan, excuse me, to identify that, because it is such a large site, how you break it up, where the water is going, different areas. But generally going from a wooded to a grass site, and they do not consider, just want to make it clear, they do not consider the panels themselves as an impervious surface. What you're really going from is a wooded surface to a grassed surface or a vegetated surface. It does not alleviate the requirement to handle the quantity of water and the peak discharges that come off that site. We still have to mitigate all that. But from a water quality standpoint, it's a large grass field.
And just so you know, maybe Hopkinton's done 5 solar projects too, and we have had positive experiences and negative experiences, and that's why people are here, because the experiences have both been good and bad. And every developer is different, and your experience might be great. You know, you can have a master's degree, be a doctorate of solar panels. but trust is a big deal, you know?
I respect that. Yep.
It's commercial enterprises, or I was gonna say like lawyers, you just can't trust them. But realistically, you know, I was explaining to my granddaughter tonight that here's commercial and here's how commercial helps our community, and here's residential, and here's how residential helps our community, and here are the pros and cons of both. There are pros and cons to both, so we're talking about your worst case scenario, that they're all gonna need to be addressed.
Understood, thank you.
Yeah, and I'm for commercial development. I've always said I'm a champion of alternate energies, solar in the right place. If this proves to be a viable commercial program that can be installed, as long as I can feel comfortable with it at the end of the day, we need this type of development. But it has to be sensitive to not just the comprehensive plan. It's gotta be sensitive to all the needs of the community, and it's not just the abutters. You know, it's everybody who's hearing it, watching it, benefiting, not benefiting. Feed my house, I live close to that area, I'll take the energy. Anyway, thank you.
Got it. Anything else?
I have one point related to that I wanted to raise. So the state has mapped areas of core forest, they call it. It's areas that are over 500 acres of contiguous forest, and these places are important because we have very few of them are left. So the ones that are over 500 acres are very significant, and they're mapped. This site is on one of those cores, and it's over 1,000 acres, actually. And so, you know, that makes it really unique in the state landscape and part of our forest resources, most of which are really limited now to the western part of Rhode Island, and many of these cores are in Hopkinton. So I think what a great product would be, and any follow-up plans would be to overlay that layer of the core forest that exists in at least part of this site. It's certainly bigger than the site. And try to retain as much of that core, and even if it could be retained to the 500 acre threshold, I mean, it's greater than 1,000, the best of your ability to retain that core and, you know, have it remain for future generations would be great.
Good point, thank you. Planning board, anything else?
Could I just ask one question? Is that resource through Department of Environmental Management
Yes.
or USDA or?
Yep, it's a RIDEM public GIS map.
It's on the GIS mapping, thank you.
Jim, anything from your end?
Well, from what I hear from the planning board and others, that you're not confident in the status of this property with respect to zoning. So if, in the interest of facilitating this issue, the planning board could ask your solicitor to review the zoning certificates that have been done on this project to date, along with the letters that have been written by previous zoning officials, and also the legal opinions upon which they wrote those letters, and review the whole thing. And let's get to the core of this and get somebody to determine what can be done on that property and what can't, because otherwise we're gonna go in circles. And in order to facilitate that, I think something should come from the planning board, because our solicitors don't engage developers directly. They don't work for developers, they don't work with them, they work for the town. So I'd like to get this issue settled right here. Before we go any further with anything, okay, let's find out, are the decisions that have been made, opinions that have been rendered, valid, or are they not valid?
Well, that's an interesting question. I mean, I certainly don't want my personal opinion to drive the bus. I mean, Ron points out quite correctly that, you know, the town has an opinion from its zoning official. One might say, well, what more do you need? It's just that Al Giorio's not convinced. And I don't wanna call her out, but I simply think it's incorrect. Now, that doesn't mean that we need to tear the lid off the can and spend hours delving into it simply because I'm not comfortable with it. If all the other members are good with it, I stand alone, that's fine.
I think that we could have some backlash if we don't look into it and rip the lid off the can. And I would prefer that we get that clarification from the solicitor. I don't think it's a good idea for us to leave that hanging out there because we'll be crucified.
Yeah, specifically in the context of all the different zone change amendments that have occurred recently, a zone change amendment like this one, is the opinion of the town that this is invalid because it's a different project now being proposed on the same piece of land? I think we need to know that just conceptually, in addition to specifically for this project.
So it sounds like the answer is yes.
Yeah, I mean, if I was the applicant, I wouldn't know what to do from this point forward. How much money am I gonna put into something if it turns out that I can't do the project? So I think really what the planning board should ask our solicitor to do is review the documents that have been prepared by town staff in the past, review them, check them for validity, and measure them against our current solicitor's opinion. I mean, that's all, I mean, beyond that, what do we have to go on? Otherwise, we're gonna wind up in court, somebody's liable to challenge this, the whole thing winds up in court, and then we fight it there. So, I don't know. I'm trying to facilitate something here.
So listen, planning board members, do you want to direct the solicitor to review the status of this application within the context of history?
I would say yes before we get to all those fast forwarded questions that I started going down that road.
I think I would
Start
want
at
it
the
if
beginning.
I was the owner and the
Yeah.
developer.
Two yeses. Three.
But the final word, what is legal and what is not legal, yes.
Okay, so the answer is yes. Do you need a motion, or is it our consensus adequate enough to direct the solicitor to move forward?
Consensus is fine.
Okay, done.
Mr. Chairman, a question of point of order, if I may. My name is Andrew Teitz, T-E-I-T-Z, and I'm an attorney representing one of the abutters, Thomas Skolko, which owns about 250 acres abutting this. And I would just like to request, if you're requesting your solicitor to issue an opinion at this early stage of pre-app, that I would also be able to submit something in writing to the solicitor with our views on it. Otherwise, the solicitor is only going to have one side of the question, and then we're going to get to master plan and we're going to go through it all again. I do appreciate, I think it's good to deal with this right up front, but I would like just that opportunity to submit something in writing to the solicitor as well. That there, be equal time provided for people.
It's a point of order. I see no difficulty with that. This is a pre-application hearing. This is not a court of law. I'm not the judge.
I understand, and I'm
If
not
you
giving
would
you
like-
any of the arguments on
If
substance.
you would like
I
to
just-
submit something to our solicitor, I see no reason why you should be prevented from doing that.
Okay, thank you very much.
Very good. It's not quite a public comment yet. That was a point of order, so it had to be entertained. So, anything else? We're good? Anything from you?
Three things. One is that 40%, excluding wetlands also, stuck out to me, as a condition of the approval. The, decommissioning comment that you made, I think Hopkinton has been treated unfairly in the past in terms of decommissioning, and I think we would be wise to, acquire quotes from their engineers, from our engineers, to get a real sense of the accurate cost of decommissioning. And the third point, and I'll let Harvey Buford speak more in depth about it, the traditional Narragansett Trail cuts through this property and has been out of use since '95, bisected that trail. And in addition, there is a stone landscape on Coon Hill on the property that is of interest, and I won't, Harvey's better to speak on the details than I am. I just wanted to bring it forward.
Excellent, thank you.
Good.
Anything else?
That's,
Sorry, could I get those two things again? One was stone landscape on Coon Hill, is that
Coon Hill.
Coon Hill? And the second one was a trail,
Narragansett Trail?
Narragansett Trail.
Narragansett Native American Trail, is that, or
The name of the trail is Narragansett.
Oh, it's just called Narragansett
Trail. I believe it's from the Appalachian Hiking Club. Like I said,
Has it been mapped, do you know, or
Yes.
a location
Yeah,
of it?
Yes.
Yeah.
be something that,
Yes.
Geodetic survey maps.
some,
We'll talk about it.
great.
You haven't hiked portions of the Narragansett Trail?
I
I know you
hike
better
in New
than
Hampshire
that.
in the big mountains. It's too flat in Rhode Island.
Oh, boy.
I understand. Okay, very good. All right, so if there's nothing else, I'll presume from our audience this evening that there might be some public comment. Now, before we see hands, there have been two. Sharon was up first, and then the gentleman in the back. You can go second, and then I'll take hands.
Sharon Davis, Cedarwood, New York. I wanted to ask him about where he was in the process with National Grid's pre-approval. And the other question was, on that map it still says 215 acres, and they made a statement that it was only going to be 59%. So
Sergio, if you would be so kind.
What's the question? This says 215 acres?
right, but then you said
That's the-
something about 59% of the property.
This is the solar lot area. That's the lot that encompasses the entire solar project, which does include areas that are not going to be developed with solar. So the actual solar field is smaller.
What?
The actual solar field, I thought I said it. Oh. 215 acres is the solar property. Yep, so that's 59% of the lot, correct?
And the lot's 275 or something?
252?
The lot is 252, yeah.
Okay, so it's 59, you said, percent, okay.
The solar panels itself is 59%. I don't know what that acreage is, I have to do the math real quick.
127 acres.
Sure, and as far as the National Grid process, we're through the pre-application stage and we're on to the initial application, and we've already had the preliminary review with the National Grid team.
But you don't have the letter yet that says you can go forward?
No, we have not gotten that far. That's at the end of the road.
When you say at the end of the road, are you talking about when you turn it on, or just to even go forward?
So the review process with National Grid is iterative. There's sequential studies that they do. When they complete all those studies, that's when you get your interconnection agreement, and then that's when you can go forth with construction. And then
That's what I'm talking about.
Yep.
And what kind of lead time are we talking?
It's from our perspective, we wish it'd be quicker. I mean, right now I'd say we hope to be complete with that process within 12 to 15 months.
Okay, thank you.
Sir?
I'd like to wait till the chairman comes back, please.
Oh, you wanna wait for Al? Oh, he told me to let you go. Okay, who's next? Hi, Barbara. You can go next.
Thanks.
I just have a question for planning board and then for Jim Lampier. I have two questions. One is there a sunset clause on a PUD if no work has been done? And I don't know the answer to that, and I don't expect you to answer it right now, but I don't know if a PUD has a sunset clause if nothing has been done after 20 or 30 years. So the other question then is, what is the underlying zoning before it was commercial special? Because commercial special is separate from the underlying zoning originally. And I don't know what the original underlying zoning was. And I think you will find that out when you do that zoning information, because you need to find that out.
it's
I don't
my
expect you to
understand-
answer it.
Well, I don't think this ever was a PUD, number one.
It was never a PUD,
I don't believe so.
so if we made a commercial special, what would still then be?
The underlying zone under it was light, two zones, light industrial and RFR.
So it was RFR 80 and light industrial, and
Yep.
it was not a PUD,
Mhm.
it was commercial special, doesn't have
Right.
a sunset.
A PUD, well, a PUD does have a sunset. This wasn't done as a PUD
Exactly.
because we didn't have a PUD ordinance in effect at the time.
Right, so
that
just
this was
commercial
done.
special.
This was rezoned commercial special,
Does
right?
it have a sunset?
I would say no.
But if it did, one part of it's RFR 80 and one part is light industrial.
That was the previous zone. That was the previous zone, yep.
Thank you.
Young lady, you had your hand up.
Just too big for me. Move it down. Okay. My name is Liliana Failure Champlin, and I live in Coventry, 978 Tile Gap. But my grandma lives here, and I've like kind of grown up here basically.
A little bit closer.
I've been here for I've been here a long time, and I sort of agree with the whole solar panel idea, but as the type of person I am, I care a lot about this town since I've grown up in it since I was a baby. My nanny and my papa mean the world to me because that's my nanny right there. And there's only a few things that can top that, which would be my friends, my family, and animals. Animals take a special spot in my heart, and they will always hold that spot. And I'm not gonna beg for this not to happen because I agree with the solar panels, and I agree with the whole, like, to make money. And I would appreciate if you could save a little room to make spot to make oh my god, I can't talk today. To make a spot for the animals, because there is a lot of animals that are there, especially with the wetlands. There's a lot of animals that are there, which include salamanders, frogs, fish, a lot of things like that. And they don't really have anywhere else to go, so you have to be careful with that. And predators, you have to be careful with that too, because if they have nowhere to go, then they're just going to be roaming around. And the last thing I want is, so my nanny's cat likes to go outside, and the last thing I want is for him to get hurt because I love him. And I would just appreciate for a little land to be left for those animals in need, because they were born there and and they would love to live there for the rest of their life. But I understand leaving trees and grass in would maybe not be what you want to do, but it would help a lot. Thank you.
Okay, thank you very much.
Follow that up.
That's a tough act to follow.
All right.
My name is Peter Conopast, Mr. Chairman, Planning Board, officials of Hopkinton. In pure transparency, my property is down here on Woodville Road, so I'm not affected by this. The Stokels are here, and I'm down here on the road. So I'm east and down, okay? But I'm here for a different reason. I've been watching what's going on in the town. And Mr. Chairman, you know me, please stop me if I'm going off. We've done this before. Been watching what's going on in the town. The other transparency is I was on the planning board from 1982 to 1992. We did the first comprehensive plan. We did the revision to the second comprehensive plan. You had a series of people that spent a lot of time, devoted a lot of effort, and reached out to a lot of people in this town to talk about what Hopkinton is and where we want to be. And there's a green zone of 95 on each side as you come out of Westerly going up. And the people said, we want to keep that. And we spent a lot of time taking a look at where light manufacturing, where development could be. This was not done politically. It was done with a lot of people that had different views about things and a lot of long nights. And our first plan was accepted. And going into our second plan, there was this development called Grayburn. And there was a lot of issues about that, but the town and the people were able to work through that. And we developed specific zoning for that. But the zoning was about keeping the area in its natural state, allowing for the development of a huge golf course, PGA golf course, resort. It made sense right off exit 2. I wasn't happy with it because of totally personal issues. I had to go there, in and out every morning. But on the planning board, it made sense to me. What we have here is not that. And when I take a look at this spot zoning, which is what the comprehensive plan was preventing this. This is why we did this. I remember coming here in town meetings and having people say, I moved out of Warwick because Route 2 got shaved off and Target got put up, and I moved here because of this. And we are doing the same damn thing in this town. So I think the citizens of this town have to think about it. If this is what we want to do, that's fine. But if it's not what we want to do, let's think about it. And let's take a look at the comprehensive plan and say, are we going to enforce this or not? You know, I've always had this issue about when you work with people and things start happening and people don't really understand what's going on in terms of business or personal life. I always raise my hands and say, I just want to know what the rules are. Because I like the game. I want to play the game. But what are the rules? The rules are changing in this town for a few specific people, and that has to stop. We have to think about what it is that we want Hopkinton to continue to be. And as a person that has spent 12 years in the planning board and working with a lot of town councils and a lot of different forces going back and forth, I think we need to say, are we going to enforce what we have, or are we just going to keep changing because someone comes in? That, to me, is very important. And if we want to go this way and cut down hundreds and hundreds of acres of trees to put up solar power, if that's what the town wants to do, that's fine. But we shouldn't be doing this because a few people want to do it. And I really think you're throwing out the comprehensive plan if you continue to do this. The other thing, and this is a totally personal thing, try to be transparent about this. There's some beautiful aquifers up here. I get my water tested every 4 or 5 years, and these people say, Peter, stop doing this. You have some of the best water in Rhode Island and southeastern Massachusetts. It's hard water, but it's clean. It's one of the cleanest waters in southeastern New England. We have a couple aquifers underneath this ridge. So one of my concerns is I'm hoping to take my farm and give it to my children and my grandchildren. Well, you know what the ledge like is like here? You have any idea? I had to put in a septic system couple years ago. It wasn't fun, because this is all ledge. And when these things fail, and nobody's there with a bond to clean this up, all of these toxic stuff out of the solar panels are going down into my well. Okay? And I want to know who the hell is going to be responsible to clean that up. And I already know the answer. It's the town. Because the bonds and all these other things that are put together are all vaporware. So I really want people to think about, is this what we want Hopkinton to look like? As I didn't move here for this. I moved here for a green space, community, and a good place to be.
Mr. Chair, do you want us to hold to address comments after everyone's spoken?
Yes, please. Pass these around to whoever wants them.
Just wanted to introduce myself. I'm Mike Warner. I was chosen by the Town Council of Hopkinton to be one of your representatives to the Wood Pawcatuck Wild and Scenic Rivers Council. It's been a long time coming. We've been waiting for the council to come up with some paperwork, but given this hearing, I threw together this sort of quick overview of what it is and how we are now federally recognized. I just want to read a couple of highlights, please. The Wood Pawcatuck Wild and Scenic Rivers Council became part of the federal protected areas. In March of 2019, we received the National Wild and Scenic River designation. The watershed is now considered a partnership wild and scenic river system under the federal Wild and Scenic Rivers Act. We received national park funding as of, I think, just this month. We just got our first check. The Wood Pawcatuck watershed's 300 square mile area includes 7 major rivers as well as countless lakes, wetlands, and smaller streams. The Council's mission is to help preserve, protect, and enhance the special environmental, cultural, and recreational values of the Wood Pawcatuck watershed. 100% of Hopkinton is within this wild and scenic watershed. Canonchit Brook is a covered tributary to the Wood River, goes all the way to the Wood River. It is a covered tributary, as is Tomahawk Brook, which goes all the way to the Pawcatuck River. I just wanted to urge the planning board to protect the federally protected waterway of the Wood Pawcatuck Wild and Scenic Rivers. And I put in on the last page, in case you're interested, there's information, there's a website through Wood Pawcatuck River Watershed Council.
Very good, thank you.
That's it, thank you. Do you have any questions?
Good evening, Chairman Diorio, Planning Board, and guests, members. My name is Carrie Robinson. This is Corey Mott. We are members of the Appalachian Mountain Club. Our membership office is located at 10 City Square, Boston, Massachusetts. I am a member of Rhode Island's Narragansett chapter of the AMC, as well as chairperson for our chapter's Trails Committee and manager for the Narragansett Trail Restoration Project. Corey is a member of the Connecticut AMC chapter and secretary for the Narragansett Trail Restoration Project. He's got a few maps for you to look at. I'm just going to speak briefly tonight because I'm sure others want to have their say. As the applicant's concept plan note number 5 states, existing trails are present on the property and shall be located for future permitting. The subject parcel contains a segment of a 44-mile-long, 87-year-old trail named Narragansett Trail, which follows tribal paths and other roads and trails stretching from Warden Pond in South Kingstown, Rhode Island, to Lantern Hill, owned by the Mashantucket Pequot Tribal Nation in Connecticut via Hopkinton. The section on the applicant's property is a significant section of this historic trail and is part of our current ongoing 3-year trail restoration project in celebration of our chapter's 100th anniversary in 2021. The Narragansett Trail on this particular section highlights pre-contact First Peoples historic and cultural artifacts and structures, and which is why this particular piece is so valuable to preserve. The trail is clearly evident where it is bounded by stone walls on both sides, but some sections are not so obvious. Therefore, the Appalachian Mountain Club would like to offer to site locate it to ensure that it is accurately represented on all future submissions for permitting. I thank the Planning Board and the Town of Hopkinton for your time and support.
Thank you very much.
Did I get one?
My name is Paul Boyce. I live on Woodland Court Circle, right around that, and kind of really abut this whole project. I'm sure you're aware that we already have one solar farm off of Palmer Circle along the highway. There's another one planned right next door to it. Now we're talking about a third solar farm in that particular area. How many more solar farms do we have to have? No residents are really receiving any large return from having an adjacent solar farm to them, at this particular point in time. So that's where my concern. But the other concern is if you look at that Palmer Circle Road, where it goes by this proposed project here, that's an area that a lot of people walk. They walk their dogs. They walk down to the swimming pool with their grandchildren. And that particular road is not a highway. So the amount of wear and tear and damage to that road that the town's going to have to accept if they put this project in, it's going to become, quite consequential in this whole, process. So I understand that, people want to develop land, but at this particular location, we're just getting squeezed by solar farms at that particular point. And it takes away some of the scenic beauty of just walking down that road. I've only lived in the area for about 4 years. When we first moved there, I noticed that they were having a problem with the brook that runs underneath there because beavers kept blocking it off and we had flooding all over the place. Get a big heavy rainstorm and that former golf course has 2 or 3 ponds on it. It's all overflowed from the brook that goes through that particular area. So adding this large project may not be the best use for that particular land. So considering all of that process, I'm sure you're aware there are these other solar farms there. They have to have come before you folks and talked to you about it. So it's really starting to get too much in the way of solar farms, down in that particular area. Right down the road from Woodville Alton, there is a medical center, medical facility, that's located there. So we're going to put one even closer to that process. So all these small things, sometimes we lose them in the process of looking at a larger project, that's going to go on. We already have another business down there. It's a software company off the other end of the Palmer Circle. And that's it. We don't see a lot of traffic going because people don't come around. But if these are the buildings going in here, and especially if we're talking about a warehouse, there's going to be a heavy amount of traffic that's going to come through there and in that process. And I hope somebody does a traffic mitigation plan because living there, it's difficult to even get out of Palmer Circle in the morning to go to work. So it's a lot of traffic that comes through there at certain times of the day. So we're gonna add more traffic to this. So hopefully we take all of this into consideration before this project is approved. Thank you.
Very good, thank you. Harvey.
Harvey Drew for the Conservation Commission. I just alluded earlier when I was up that this project is one that I have personal knowledge of because I've hiked the Narragansett Trail there. Much of it is well defined. It is getting to be almost an expert as a non-native to say what is what appears to be a significant cultural landscape. Some beautiful stone structures up there and some beautiful stone walls. I looked at the plans, the internal, just rough scaling, the internal mileage of stone walls shown as a shadow underneath the plans here was about 3 miles of internal walls up there. And I know they're not all on there, at least I don't believe they are, because there are double walls up there where the laneway goes, like where Narragansett Trail goes. So again, I had called Doug Harris, our contact at the DIPO's office for the Narragansetts, and because he's had an illness, he's not back to work, and he wasn't able to come tonight. But I would just encourage the applicant to work with him, ask him to come out, or rather ask Mr. Harris to come out. And you find he's a very engaging person, and that would be one of the things, just to identify what's up there, because obviously if you were to put this solar project on, what I assume your expectation would be that you would just come in and everything would go. And there might be ways to mitigate things up there. Thank you.
Very good, thank you.
Oh, just a question as to what is the next step in this process?
This is a pre-application hearing.
Yeah.
The applicant would decide what to do next. Another pre-application, the next step in the process, entirely up to the applicant.
Understand. It will be posted, if they do return?
It will be an agenda item for certain.
Thank you.
Very good. And Mr. Tights, was there a hand there?
Yes, I would like to speak if I may.
Of course.
For the record, my name is Andrew Teitz, T-E-I-T-Z. I'm an attorney with offices at 2 Williams Street in Providence. And I've been here before. I've dealt with some of you in the past on other issues in town. I'm here tonight representing Tom and Cynthia Skulko, although the property is in Tom's name. There are 3 lots immediately abutting this property, lots 37, 38, and 42, and in addition to which there are also other lots 39, 54, and 44 to the south. Altogether, roughly about 250 acres that are there. This property was bought many years ago and put into farm, forest, and open space for preservation. And in fact, there is an approved farm, forest management plan for the property. That's what they bought the property for, that's what they're doing, that's what they care about. And clearly, they're very concerned about this. The destruction of all these acres of forest. You've heard about all the environmental impacts. I didn't know about the trail, but that's something else. There's a lot of issues there. Everybody's kind of talked about that, so I won't repeat that. What I will talk about specifically is, I think, the legal issues. And I will put it in writing for your solicitor, but since you've given the other people a chance to talk. Some of you know, I think, I've been involved with land use for quite a while. In the 1990s, I was a member of the Land Use Commission, which wrote the Zoning Enabling Act of 1991 and the Development Review Act of 1992. And I've also written zoning ordinances for more than 3/4 of the cities and towns in Rhode Island over the years. And at least to me, it is crystal clear that while it may not have been called a PUD, it was the effect of a PUD when it was adopted in 1990, as the chairman indicated. It was, all right, we are allowing these specific uses, and my understanding is that there were 15 enumerated uses in the zoning ordinance. These are allowed with these conditions. And it may be true that that doesn't expire, and they still have the right to do those 15 uses with those 15 conditions. But it appears that you had, a zoning officer years ago, 9 years ago, with another property, who wrote a letter which is being relied on now, which erroneously interpreted this and basically said to someone who was trying to develop, yes, you can have your cake and eat it too. You can have any use we've got in the zoning ordinance for what this property is zoned now, and you don't have to comply with any of the special conditions. You can get away with it. If someone wanted to build any of the things here, as I said, I don't think they're basically allowed to build anything other than the 15 enumerated uses, and they're also required to meet the conditions, including the 40% open space. And if they're subdividing the lots, then it's clear they have to meet that 40% open space on every single lot that they create. They can't say, okay, even if they did cut the solar and put 40% there, they can't say we're putting no open space on the other commercial uses along the road. It's 40%, it's either gotta be one lot and 40% of total, or every lot has to have that 40%. And even if all this other stuff is approved, even if they were saying they could do any commercial use, the fact of the matter is solar isn't a commercial use. It's not listed in your ordinance as allowed as a commercial use, and the Rhode Island courts, actually at the behest of renewable energy advocates and owners, with Mr. DePasquale and his wind turbines, he was successful in getting the Rhode Island courts to determine that these renewable energy facilities are industrial. They take a raw material, they take sunlight or wind, and they turn it into electricity. Therefore, the Rhode Island courts have said they're an industrial use. So even if everything else were true about every commercial use being allowed, the solar would still not be allowable. And finally, just as an aside on zoning certificates, and again, I'll leave most of this for your solicitor, but the Rhode Island courts have said zoning certificates aren't controlling. They're not binding. People can't appeal it and go to the zoning board and say the zoning certificate's wrong, but consequently it means that a developer can't rely on the zoning certificate. It's to provide advice to the developer, but the zoning ordinance still controls. And if the zoning certificate is wrong, then it's wrong, and there's no magical vesting that's created by a zoning certificate. Because if you think about it, there's no notice when a zoning certificate is granted. Somebody comes in and asks for a zoning certificate, they get it. And then if that was suddenly something that vested, you could have people who either, you could have either a zoning official who makes a mistake, or more nefarious circumstances, a zoning official who does a favor or does a favor for money, and then there's no way that could possibly be appealed. And in fact, that's where the case came from, was a Chandler Hotel down in Newport overlooking First Beach, and they got a zoning certificate that said that they could just expand the rooms willy-nilly, and they had afterwards, when it was challenged, they said, oh, we have a zoning certificate. And the court determined, no, you don't, because there was no way to examine it and challenge it and have the light of day. So that's the philosophical aspect of zoning certificates, that they're not the holy grail. So with that, I know there are other people talking late, but if there are any questions, I'm happy to answer any questions you might have.
Very good, thank you very much.
Thank you.
Yes.
Spears, I'm the Executive Director of Thomas Fogg Museum.
And I'm Wanda Hopkins, I'm a resident of Hopkinton, I live right on Diamond Hill Road.
And we're both Narragansett. And so we wanted to speak to the fact that we've been partnering with Tom Fogg Museum. For full disclosure, she used to be a board member there, used to be an employee there at one point as well. And we've partnered with the Hopkinton Historical Society and the Land Trust over quite a few years on the ceremonial and historic landscapes here in Hopkinton. And so one, we thank you and applaud you for actually caring about that. And so I would like to just reinforce the fact that we would really like this project to really look at and carefully mark them. I'm also really concerned about the Narragansett Trail. That is a historic trail that's millions of years old, that should really be considered in this project as well.
Just that, listening to some of the ideas and plans that have come up tonight, my children and I, we love this area. I take them to show them the historical sites, and my concern is that they won't be here for my great-grandchildren. So when all of this planning is going on and building is going on, if you could just keep that in mind, that there are people here who have been here and who, you know, those places are really sacred and special to us.
And for full disclosure, I live currently now in Charlestown, but I grew up and lived in Hopkinton. So this landscape is a landscape that is near and dear to us in general as Narragansett people in South County. It's really important. So we're here to support keeping South County rural and keeping the landscape intact and remembering the ceremonial and cultural spaces. Thank you.
Thank you.
Dan Jensen, 30 Prospect Square. This testimonial is directed to the developers of this project. Hey, I'm Dan Jensen. I do a lot of recreation in town, and I just want you to know how the solar has affected my life. Just so you guys know. Okay, they've approved 100 acres of panels, already approved project. If I stand on my deck, my apartment over here, looking north, I'll see the entrance. So that's done, 100 acres. I'll see these, probably see these panels. Where I boho, where I have permission, High Ledge Farm. If I walk 800 feet through the woods, I see a 60-acre solar field. In fact, when I drive down 91, and I make a left on the Burgervik Road.
You're talking to those folks.
When I drive down 91 and make left on the Burgervik Road, I purposely do not look at the field, so I stay in my bow hunting mindset. Now, I small game hunt on Reynolds Farm right up here. Reynolds Farm here. So what I'm saying is that I live in Rhode Island to enjoy what I do. The solar industry is killing me. It's killing me.
Sir,
we have.
Sir.
Can you direct your conversation?
You're talking to us.
So I've had it with this. I'm just hoping this Groundhog Day of waking up to a new project every 6 months will stop. And when it does stop, maybe we should all have a large party. But seriously, this project is really big. If it was scaled down to include open space, to the degree that the original golf course was, maybe it's a win-win. But at this stage, it's just very emotional and difficult to get the text. I wasn't planning on coming here tonight, seeing another 127-acre proposal. It's just ridiculous.
I understand. Thank you. Any other hands this evening?
We're on the train.
I see one more. Once again, this is your opportunity to guide the applicant. If you have something to say, now would be the time.
I'm Edward Lowe from Brook Drive in Hope Valley. There's an underlying issue with our town government that I hope would get from you to the town council and then down through the town manager to the town officials. That issue seems to be that the town officials are unilaterally deciding issues of what enabling ordinances mean. And in some cases, they're doing whatever they wish to do or whatever they consider to be right. But it's not, especially after listening to Mr. Tights and his explanation, the fundamental problem is that the zoning official cannot issue that certification, that zoning certification, and give the developer the impression that you're good to go. They're spending lots of money developing their plans, developing their projects, and under the impression that the zoning official has given them, has rendered an opinion to them that they can go ahead with, their project. That's a systemic problem in our town that needs to be rectified, and I would hope that you would be able to go use this as an example to go to the town council, through them to the town manager, and get this rectified such that town officials are acting in accordance with enabling ordinances for zoning changes, are acting in accordance with enabling ordinances for changing from RFR 80 to solar, or from special use commercial to solar. We've seen two distinct problems here that have led to huge problems. One of them is the lawsuit against the town right now. And that needs to be corrected. I would hope that you could offer that as a suggestion to the town council. I appreciate it. Thank you.
Thank you very much. I would only mention as an aside that that kind of comment really belongs at a town council meeting, yes? Anyone else in the audience this evening? Yes, sir.
Godfrey from Rockville. Questions. Who is sending these developers to Hopkinton? Where are they coming from? Why are we getting picked on in Hopkinton? It's like a cancer around here. Every time we turn around, we see something like this. Green forest being knocked down. Rhode Island's got a lot of other dead space. Why are we getting picked on? Every time I turn around, I see this. I saw this, and it made me sick to my stomach. It's not a country place anymore. I'm disappointed. Moved here 4 years ago, and I'm watching it get knocked down. All that land, all those forests, everything that's in those forests. I agree with solar, but not knocking down trees. Find some dead space. So I don't know where they're coming from. I don't know who they're being, who's sending them here. But I feel like we're getting picked on in Hopkinton. Thanks.
Very good, thank you. Anyone else in the audience? I see no hands. Must be that time of night. Planning board, any last comments for the applicant? No. Applicant, any closing statements? Please be brief.
I'm sorry, what's that?
Please be brief.
You're kidding, I just wrote out a whole speech.
We'll get to it.
I'm glad that you wrote it out. If there are any comments that were pertinent that you would like to address, please.
There were. First of all, I think I'd just like to applaud the community for being so engaged in the process. I mean, I think that's just proof that the process is working, and that's why we're here. I mean, this is a pre-application. We're receptive to these comments. I mean, I want to stand up here and just assure you this is not falling on deaf ears. Everything that we're doing here is very thoughtful and very considered, and so we're taking your comments and we're listening to them. So I just want to make that point clear. There were a couple things. First and foremost, and unfortunately the gentleman who brought it up, I don't see him still here. He mentioned toxic materials on site. There's going to be none. There's no toxic materials in the construction of the solar project. I can kind of just explain quickly what it's composed of, although you probably already know, being that you've had multiple projects come through. You're talking about steel foundations, steel racking, right? The panels themselves consist of aluminum, copper, silicon, and glass. The wires are regular electrical wires. They go into transformers and inverters, which is all utility grade equipment. It's all proven technology. It's been around. You can currently find them in use on the street, in the substations, and within those there are no toxic materials. The transformers have transformer fluid in them, which is either an FR3 fluid, which is a vegetable-based fluid, or it's a mineral oil, which is an insulating oil. But again, I just want to stress the point that there's no toxic or hazardous materials that are being brought on site.
About this?
Not now.
Not just yet. Not just yet. Let the gentleman speak, please. You have
And
your
then,
opportunity.
the other point, we got a lot of comments, and I'd like to applaud the young lady for her speech and her kind of open-minded and critical thinking about this project. And you touched on an area that, also means a lot to me with regards to the animals and the habitat. We're not, where the solar project is proposed, we're not going over any map or known areas of critical habitat. We're staying completely out of all the areas of wetlands. We've observed those. We've done the wetland delineation, and so we're not destroying any of those critical areas of habitat. And we did look for it. I mean, we are cognizant of it. And so I just wanted to make that point, and also too that we're not preventing movement across the site. Animals will be able to get from one side to the other. We're not preventing them from moving across. And again, like I said, we're not aware of any areas of habitat on the array area itself. So net, we're not, in our view, creating any sort of material impact to any habitat on site.
Okay.
And then I don't know if you want me to address the general question of why we're here. I think it's a good point to consider. We're proposing, again, I'm speaking just to the solar. There's obviously additional components to this, but it seems like a lot of the attention was focused on the solar tonight. It's a solar project. It's designed to remove our dependence on fossil fuels and putting carbon into the atmosphere. And so part of the reason why we're here is because Rhode Island has taken a charge on this transition. They viewed it as important, and even a couple weeks ago, the state has announced initiatives to move to 100% renewable. And so an understanding where you're coming from as far as a land use perspective, I just want to put back out there that the reason why we're here and the reason why there's developers in the state is because there is an issue of climate change going on and putting pollutants in the air and relying on fossil fuels for power generation. And this is the response to that. And this is something that has come from a state level where there's state level programs that have incentivized us to be here.
Don't go to that.
You want to go? I mean, elaborate.
No, we don't need to go there. This is your opportunity to say something. I'm sorry, no, you had your opportunity. The gentleman speaks. When he's done, we're done.
That's all. Thank you.
Okay, great, thanks. Okay, again, pre-application meeting, there's no motion by the planning board. You have our comments. We look forward to your next presentation.
Thanks.
I appreciate everybody's input from the audience. Thank you very much. We look forward to your continued cooperation and participation. How's that for putting it on? It's all boiling. All right, continuing. Next item on the agenda, the solicitor's report. None.
No solicitor report.
Planner's report.
None.
None. Any correspondence and updates? Yes, there is one.
Jim, this was on the ground over there. I don't know where it came from. But yeah. Okay. Yeah.
Your comprehensive plan amendment correspondence.
Yes. Got that here.
Jimmy, you want to?
I just want to state that the statewide planning program approved our amendment to the comprehensive plan prohibiting wind turbines in town.
Although there was a caveat.
Was there? Oh, Eddie?
We should allow them on rooftops or something like that.
Yeah, I read that. It's like a residential installation.
Does our comprehensive plan
I'd like to take.
address residential wind energy.
The house is gonna.
Not at all.
Boy, I tell you, that, you know, that's probably a building issue, a building department issue. Again,
Just a personal question.
I don't know. I mean, residential, you can have residential solar on your roof, naturally.
Right, so can I put a little wind, generator on my front lawn?
I'm not the building official, but off the top of the cuff, I would probably say as long as you don't exceed the height restrictions of the zone that you're in, I guess you could. You used to put antennas up there on the chimneys that rotated. Remember the old days when you
Yep, still got one.
Channel 6?
One on the roof, one on the
I would
second
be,
floor,
I
one on
would
the
be
first floor.
inclined, I would be inclined to think that they would be prohibited on residential property too, because it says wind turbine, so any form of wind turbine, so that could be.
Yeah. Haven't thought about it that much. I don't know.
Don't mean to make a big deal out of it. All right, so, next item on the agenda is public forum. Anyone in the audience wishing to be heard? Again.
Anybody wanna?
Turning around.
I see no hands. Okay, no problem.
I'll say something.
Yes, yes.
I told that gentleman that Hopkinton has already approved almost 100% replacement of our energy in solar projects. We don't need another one. And then also, I thought, the 200.
15?
No, the 200
50.
foot or yard, buffer, yeah, that we're requiring, for residential should be also required for property that's not residential. I think we need a 200-foot buffer from everybody if we're gonna do solar. That's my point.
I just want to point out that it's really over 400% that we've approved in town.
Got it. Thank you for letting him know that we don't need any more on Hopkinton's back, that we've done more than our fair share. Thank you. All right, the date of the next regular meeting is March 4th. Anybody have a problem? Is there anything else that can legitimately come before us? Nothing. I'll entertain a motion to adjourn.
Like to make a motion that we adjourn?
Motion, second. All in favor? Anyone opposed? Thank you very much. Appreciate your time. 9:05, not bad.
Good job, thank you.
Oh.
Just put it out there.